welcome to another Tech Talk Tuesday. And today we will be talking about Countdown to Compliance, the Data Protection Act. So just for everybody who will be joining us on YouTube and LinkedIn Live, my name is Justine Collins. I am your host this evening, and I am so honored and privileged to be here with some esteemed panelists who are going to give us all the tidbits, all the tips to the extent that they can about how to comply with the Data Protection Act. And make sure you stick around because there may be a special guest star or two. Who knows? So today we are being hosted by the Jamaica Technology and Digital Alliance, and we are so happy that we are going to be celebrating 40 years of the BizTech conference, November 13th to 14th. And this year's theme is sustainability and scalability, technology for the future. Without further ado, I'm going to introduce you to our esteemed panelists. So I'm going to start with Sara Newman. Sara, of course, works with Securis. I hope I'm pronouncing it correctly, Sara. Don't.
Okay. You are. Thank you, Justine. Thank you.
Andrew Nooks as well, who, of course, sits on our Data Protection Oversight Committee panel and is a privacy professional as well. My namesake a little bit, Justine Morin from Ernst & Young, and of course, Shavaniese Arnold, who is the Data Protection Officer at the Civil Aviation Authority and one of our co-chairs at the IAPP Caribbean Knowledge Net chapter. With such an esteemed panel, I think we're in for a great treat tonight, guys. I can't think of no other way of spending my Tuesday night. So let us get right into it. Before we start, is there anything that the panelists want to say to our audience just to kick things off? Don't all jump at once.
Yeah. Let me jump out of the blocks just to make my disclaimer. First and foremost, I am a member of the Data Protection Oversight Committee, but in this forum, I do not, nor am I authorized to speak on behalf of the Data Protection Oversight Committee or on behalf of the Office of the Information Commissioner. We do have a chairman at DPOC, Chris Record, who is the go-to person. And of course, Celia Barkley would be the go-to person at the OIC. All right, so just a quick disclaimer. Thanks, Justine, for that opening.
No problem, Andrew. Thank you so much for sharing. I love a good disclaimer. I love a good exclusion clause. So
if I could just add mine.
Go ahead.
Add mine as well. Because I heard you mention that I'm the DP at the Jamaica Civil Aviation Authority, but I'm not here today in that capacity. My views, my professional opinions expressed are not those of the authority either. So there goes my disclaimer as well.
Well,
so spoken like a true lawyer.
Yes. Thank you very much, my esteemed colleague. I love that. So I hope that those disclaimers mean that we're going to get some juicy tidbits tonight. So it's sort of an introduction or a prelude for things to come. So I want to just start off things hot and heavy. Today is May 28th and June is upon us. And in the Caribbean, of course, June is known for many things, such as the beginning of the hurricane season. But for us in the data protection space, right now, June is a big month for us because we're all preparing for that big thing, registration. And so I want to start off by saying, June 1, it's coming. What should companies reasonably expect in the next month, in the coming months, in terms of data protection requirements and compliance? So I'll put this out to the entire panel.
I'm happy to take this. I can only reference really the experience that Securis have had globally. So we were around when the GDPR went live in Europe in 2018. We've been there for South African privacy law, LGPD in Brazil, and around in Jamaica as well, making sure our client Surgical was ready for the 30th of November deadline last year. I think what everybody expects is that the sky's going to fall in on the day that everything goes live, and that tends to not happen. So first of all, I would say take a breath and relax. There's only so many things one regulator can do in a given day in a country of this size. So first of all, I think you won't notice any change for the first days and weeks while people going through registrations, all the documents that are being uploaded, ROPAs and DPIAs, etc. I think from a company perspective, the best thing to do is just keep your privacy program going. So, carry on those conversations, making sure that privacy by design and default is being built into all of those new projects. Make sure your records are kept up to date, add new lines to your records of processing activity, make sure your staff are aware of their requirements, but also what their rights are as individuals. And additionally, make sure that you're able to support data subject rights, individual rights from anything that you get from outside and meeting the deadlines. And just make sure that you're building that level of trust with, internally with your stakeholders and externally as well, whilst we work out, what kind of regulator, Celia and her team are going to be and what that looks like in the real world.
Thanks so much for that, Sarah. And I'm glad that you mentioned trust, because that is critical to the deployment of any kind of data protection compliance program. It's so important that the public buys in and is really sort of believing in the legislation and what companies can, do for them in terms of ensuring that their data subject rights are honored. Shavaniese, do you have anything to add?
I do. Come June, for everybody out there, and especially for the professionals, I will say you can expect a lot of questions. Expect the confusion, but remember that we are here for a reason. We went ahead and we specialize in this area for a reason. So I think many times professionals are not very patient with the people who don't know. So this is going to be the time where you will have to channel all that patience that you possibly can to work to get people to develop that culture that Sara mentioned earlier, and to help to make privacy a lifestyle. So the culture and the lifestyle. You can expect also a lot of assessments. So these are now for the people who are in the organizations who need to understand that yes, you have your privacy professional, but they can't do it alone. They need the information. They need to know what you're processing, how you're processing it in order to know if you're doing it in accordance with the standards. So they'll be asking many questions. So patience, not just from the professionals, is required, but also from the employees in the organizations and so on.
Yeah. I think Sarah and Shavaniese covered it really. I recall being an IT professional during 1999, Y2K, when airplanes were supposed to be falling out of the skies, and persons were selling out everything because it was their last days on Earth, as you know it. So I'm just going to ask you not to panic, not to sell out everything, not to run away screaming, but just be calm. The office is in a similar position to all data controllers. They're also trying to get ready. We're not as mature as other jurisdictions that Sarah may have worked in, where they have privacy laws for a number of years. The regulators have been set up or are used to this kind of thing for a number of years. Our regulator is also getting ready, and they will also have their hands full in terms of facilitating registration and everything else. So stay calm and continue with your program. Listen to your experts. For the experts out there, talk with your executives. Just there will be a lot of anxiety. There's a lot of fear mongering that's happening in the space, and it will cause a lot of anxiety. So it is your duty now, as persons responsible for the program, to quell the concerns of your executives and have everybody remain calm.
Thank you for that, Andrew. Justine, do you want to add anything?
Yeah, I would just side with my colleague there. We serve a number of clients, helping them to stand up their privacy programs. You do hear executives and boards being a little nervous as the date gets closer. That nervousness is increasing, and we tried to spread the same message to let them know that, they've been doing the right things so far. They've been putting in the right controls. And on day one, don't expect much to change. I think there will be probably a couple of actors out there that will try to test different companies and their response. So those who are prepared, they will definitely need to be ready to respond to those early actors in the game. I mean, privacy is now a human right. Essentially, that's what the law has allowed for. So as of June 1st, the regular folks out there and customers can exercise their rights. But having said that, as Andrew says, Sara says, it's probably far and few cases that we'll start to see come out. The Office of Information Commissioner, we know, is going to have a huge deluge of registration applications. There are some companies that are still in the process of implementing their privacy programs and not quite ready. So I think it'll be kind of like a slow rolling start to this whole thing. But ultimately, I mean, what we have to recognize is that Jamaica's kind of moved to the right place, enacted privacy law. Entities that I've seen and been supporting here have taken it very seriously, and that's been very positive. And it will set us up for more digital innovation in the future, which is really what this sets the foundation for the whole country to move forward. Particularly as we know NIDS is coming out soon, and data privacy was a key requirement for NIDS to come out.
I want to add something, Justine, before we close out. I want to make it clear from my understanding that there are several sections of the law that came into force on December 1st. So in essence, the law has been in force for about 6 months, as we see it, and the sky hasn't fallen, right? There are certain sections that were dependent on regulations, registration being one of those, and that is why registration is what has been delayed, and other sections that were depending on regulations. So this June 1st is not the start of the act being in place. It is really a continuation, and it is the start of registration. A lot of persons refer to it as a deadline and stuff like that. That timeline for compliance was June 1st, and you still have gotten some leeway in terms of getting your program ready. What you ought to do is just continue doing your due diligence, continue doing your preparation, as Sara said.
Thanks for that, Andrew. And well, everybody, I think that was very, very helpful. So we know registration opens on June 1, or is expected to open on June 1. Let's qualify it since we're in the era of disclaimers and appropriate notices. Expected to open on June 1. But certainly there has been a lot of movement, even from 2021, in terms of the establishment of the office. And it's not an altogether one, everything's going to happen at once process. It's very gradual. And certainly, as Justine pointed out, we will see some of those bad actors coming in and trying to test the system. So we want to make sure that we're prepared for that. So thank you so much for that. So I want to just jump in with another broad question. And really the reason we're here today, we've heard a lot about the what. What is data protection? Who are data subjects? What are their rights? And you talked about the law and what sections are enforced now. But there is a gap between what and how. We know what the law says for, relatively a lot. We know what is in the law, but how do we move from what to how and complying with the act? So I just want to probably start with Andrew. Do you want to jump in here?
As they say what you think about is what you attract. I was there thinking, boy, don't pick me, please don't pick me. So, but of course, I attracted the question. Um, the there are a number of things that persons need to do. One of the first things that I like to say to persons is, there's been a lot of focus on the organization and on data and protecting the data. But I want persons to understand that the law is about protecting the people who the data is about. That's the reason why we're trying to protect the data, to protect the people, and we ought not to lose sight of that. So if I should coin it, the Jamaica Data Protection Act is protecting the data about people so that we can protect the people who the data is about. And once we have that clear, we will start looking at, how is it that our processes can impact people. And if we look at our processes and we can identify the processes that has the greatest potential or could have the greatest impact on people, then we'd start looking at those processes and to see what we're going to do in respect of those processes, so that we can protect the people. I don't want to hug it. I mean, I could definitely go into the entire spiel about what to do first and what to do next, but I'd say a risk-based approach would be the best approach. Find out where the risks are to the data subjects, and then the things that are tied to those risks, the data itself, and what we're doing about protecting it. And a big part of the protection for persons is not just looking at the technical controls, but looking at the other aspects of the law, observing the rights of the data subjects, in that case, the transparency rule, giving persons an opportunity to consent to the processing where no other lawful basis exists, and so on. So I'll shoot over to back to you, Justine.
Sure, no problems. Thanks for that. And a risk-based approach is, of course, critical. And I'm glad that you mentioned as well, and I think it was mentioned before, the technical, not just the technical controls, but also perhaps legal, organizational. So I'm going to now hand over to Shavaniese to speak a little bit more about how we move from the what to the how. Shavaniese?
Okay, I love moving from the what to the how, because at the end of the day, anybody can take up the law and read it and know what is required. And it's funny because I was having a discussion with a colleague today, later in the afternoon, and she was asking me, what is the demand like in Jamaica right now? And I said to her, people know, for example, that they require a data protection officer. Those who know. Of course, some don't. But many people don't know, for example, that you need to be assessing your processing activities. And that takes us back to the risk-based approach. And the truth is, many people don't understand that until you know what data you're processing, what personal data you're processing, you won't really know how to protect it. So you need to be going through and asking all those questions, even as it relates to the very simple processes, something such as processing payroll. You need to be asking the right questions, okay? What data is involved? Who do you share the data with? What controls are applied when processing is going on in relation to this activity? Do you share the data with anyone outside of Jamaica? And all of these questions now will help you to be able to assess what your position is in relation to the 8 standards that we have under the Act. And even from doing your assessments now, that is what will help you to know where the gaps are. What are we doing wrong? And sometimes we forget to talk about what we're doing right too, and how we can do it better. Because many organizations, what you find is that They have some things that are ingrained in their culture that work so well for them, but they are willing to just change it all because, oh, data protection is here now and we need to stop doing this. No, you need to understand the culture of your organization, know how to work with your people, know how to get the most out of your people. What will get them to come to training? What kind of trainings do they like? And that also takes us to getting people to understand what the standards of the Act are and how you expect them to process the data in relation to all the processing activities. Another thing I could mention is, for example, your third-party risk management. See, we're talking a lot about the risk-based approach, ensuring that you review those contracts. You might have vendors who have absolutely no idea that they ought to be complying with this particular Data Protection Act. They have nothing in place. You're transferring data to these vendors and your risk is so high you have absolutely no idea. How will you know? You have to assess them as well. So we have to be doing a lot of assessments, your vendor assessments, your processing activity assessments, and your assets. You have various software and applications and you feel very confident about them. Oh, it's Microsoft. Oh, it's this. Oh, it's that. It's good. But you need to check. You need to assess to know what is what and how it is operating to be able to identify the risks. I will leave some of the how for the other guests.
Shavaniese, you have given us a feast, and I love it. Thank you so much. Sara, could you possibly tell us, and you know, your experience is unique because you've had the experience in the UK, presumably as well, the EU and South Africa in terms of 2018. I remember I was in London at that time, and there was so much anxiety to 25th of May, the 25th of May, and it just passed, and we celebrated the anniversary. So in your experience, moving from the what to the how, can you share probably some lessons even from those jurisdictions as well?
So I think the first thing to remember is that compliance is a journey, not a destination, right? You're never going to get there, and 100% compliance is not a thing. So anybody that says that they're 100% compliant with any privacy law is lying, unfortunately. Securus has been around for 10 years. This is all we do all the time, and even I would say that we are not 100% compliant in any of the areas that we operate in. We do our best, but it's just absolutely impossible to keep up with everything all the time. So give yourself a break and realise that perfection is not what you're striving for. And I completely agree with everybody else on the call, with regards to, risk that's what you need to look at first. What's the highest risk processes within your organisation? What are the ones that could actually result in harms to the individuals? Now, a lot of organisations will be doing processing that's really very anodyne, and that's great for them and a much easier path for them to take. But there are processes that contain information about individuals, their health, their ethnicity, their religious beliefs, their political beliefs, that in certain places, if that is compromise, could end up in actual physical harm to those individuals. So that's the kind of, we are, as Andrew says, this is about protecting people by looking after their data. And I think, the key thing to remember here is that whilst there are systems, there's a lot of organizations that still have a lot of stuff on paper and kind of forget that that's something to deal with. And I've got a couple of bits here, but it's a broad brush. And I think that the key thing to remember is that you're not going to be able to do everything all at once. That once you've finished one round of assessments, you need to give yourself dates to go back to those assessments, depending again on risk. So the high risk assessments you might want to visit biannually or at least once a year, the lower risk ones that are less frequent, time. And there's a lot of education around the people, the suppliers, the processors, as the language is, that help support that data and making them aware what their requirements are, and again, especially in protecting that data, but also again going back to the individuals, being able to support those rights when people request copies of their data, rectification of their data, access to their data. And I think what you've got to do really is sit back and settle in. This is the long haul now. This isn't a one-off exercise. And it's just learning from those mistakes and also keeping an eye globally around what's happening, because I know that Celia's been in Washington, DC at the IAPP events and seeing what other regulators are doing and talking. And it will be driven, what enforcement action happens will be driven by global activities along with what happens in Jamaica, which of course there will be breaches. That's inevitable. We just can't stop them. But there'll be other things as well. And I think it is really important that we pull out that good behaviour, because a lot of organisations, what they're doing already is completely compliant with the Act. It's just we haven't given it a lawful basis, and we haven't given it a data protection impact assessment if it needs one, and we haven't put it in a structure of a thing that is called a record of processing activity. But everything that's being done is absolutely fine. We just need to categorise it. So I think that there needs, that just take that breath and go, okay, this is the start of something that's just going to go and go and go.
Thank you so much, Sara. So certainly, I think that there are overlaps between what you say and Shavaniese just said as well, in terms of sometimes we are kind of complying, but we don't really have a name for it. You see people doing things like seeking authorization or consent, but they haven't quite sort of contextualized it. And so I'm now handing over to our in-house auditor team, Ernst & Young, my sort of namesake, Justine, to just kind of circle out this conversation on moving from the what to the how. Justine?
Yeah, thank you, Justine. And just to probably add a different angle to it, sure, every company needs to understand what data they're processing, particular personal identifiable information. To register and to comply with the law, you will be required to provide information about the information that you're processing and how you're processing it, where you're sharing it, and so on. But one other thing that's important to do is to think about how you're going to sustain your privacy program and mature it over time. Sara is correct. You'll never be 100% compliant. You won't be fully ready on day one either. And part of what we try to tell our clients is that it's a journey and that we need to keep working on it. And there will be quite a large policy suite that you will need to develop and put together that is going to sort of set the framework and the guardrails around your privacy program. And that's going to be important to put together and to develop. Some companies obviously will need to reach out to for help and support for some of those policies. It's important to have a very robust privacy policy in place. We want to have a consent and cookie management policy in place, third-party management policy, data retention policy in place. You'll also need to have quite a number of procedures in place. So understanding how in the company you are going to respond to a data subject. The law gives them a right to requests for access to know how you're using their data, or how their data is being processed, or whether it's being shared with any third parties. You have to have a procedure to respond to that. There is a time limit that you're given on how long you can take to respond to it. So you can't wait for that to happen to then react to it. You will need to have these procedures in place, know what they are, make sure your teams are fully trained and prepared to respond and follow the procedures. And last thing I'd like to say, last piece that we sort of also try to help our clients to do is to establish a governance model or program, if you will, around privacy. If you think about how privacy is managed within organizations, there's a lot of stakeholders involved, and there are obviously the data subjects. Data subjects can even be inside your organization, not just outside. So they can be your own employees, can be data subjects. There are the frontline staff, the ones who are actually touching and handling that personal identifiable information on a day-to-day basis. There's you might have a head of privacy or someone who's been appointed to kind of lead your privacy program or be accountable for privacy within your organization. You might have a privacy committee or steering committee or governance committee. And you might also have a group of executives that have been appointed to oversee privacy. You might even have a board subcommittee. So there's a lot of different stakeholders involved. There's a DPO and then there's a regulator. So when you put everything together, it can become quite complex on what your obligations are. And so one of the things that we say to our clients to do is let's stand up a governance model to help you to not only manage your privacy program, all your artifacts that you've carefully put in place, but to also help to sustain it, to continue to mature it, to work on the things that you maybe can't get done now, but you've put on your roadmap for the future.
Justine?
Justine,
Yes.
just quickly.
Sorry,
Sorry. So quickly, just talking about the how again. One of the things that I found worked when I assisted companies in implementing their program is first and foremost bringing persons in awareness of what is required, why it is required, why are you going to go through this program, right? So one of the first steps that organization ought to take is to ensure that all staff are aware of the Data Protection Act and what it requires of them to do, right? If you have that in place first and foremost, then getting the buy-in, getting the support from the team in putting in whatever policy, whatever procedure that you need to put in, it goes a far way in pulling it all together. Otherwise, it would be working in abstraction, in abstract. So we're doing this policy, but we don't know why. We're doing this assessment over here, but we don't know why, right? So in terms of developing the how, we have to communicate the why we're doing it. Unfortunately, some persons focus on the consequences of not doing it, as opposed to the benefits of doing it, right? So that's my ad.
Okay, Justine, I just want to add a little bit here. So there are two things. One, many persons know it's budget time for some people, and I want to say, add data protection or privacy, whatever you want to call it. Add it as a part of your budget. It is important. Even if it's just that, okay, I've already found someone inside the organization who will deal with compliance. Remember, registration fees there. You might have to get a few resources in place to get the thing up and running. So ensure that data protection is a part of your budget. And I want to also add this. If you don't know what to do, remember, there are people like us out there who will help you to get to the how. So maybe all some people need to do is find somebody who will help them with the how. You don't have to struggle on your own. If you go on the Information Commissioner's website, you will see, I believe, a list of approved or authorized service providers. Contact one of them and they will assist you. That's what I wanted to add.
Thanks so much, Shavaniese. I think that we have, and I really love that you have also mentioned the service providers as well as Andrew mentioning the why. So we're going from the what, the why, the how, and now she has put in the who. So I love that. And I hope you guys were taking notes while Justin was speaking about the policies. I was like, yeah, man, somebody can just write all of these down. Cookie man? Yes. All right. So I just want to take a minute to just talk about some of these things in the chat. We are having a very active and live chat. So everybody is saying very informative session. Thank you to the JTBA for organizing such a great session. And of course, please remember to follow the JTDA on our socials, which comes along the screen from time to time. I also want to oh yes, thank you so much. Look at the JTDA being so efficient. So there is a question in the chat that I just want to put out to the panel. And please remember that, guys, there might be a special guest star. You never know. So make sure you continue to be tuned in. So the risk, Jeff from the chat says the risk-based approach doesn't seem to be well understood in many organizations who seem to be treating this as a compliance versus non-compliance or conversation. Does the panel have any suggestions on how to shift those conversations to something more nuanced? And certainly I've seen that from some of my clients where they have said, we just want to be compliant and that is the goal. So I want to put it out to you guys. What do you think?
It's a really good question. And yes, I think for organizations that are approaching this part of their compliance from a risk-based approach, it can be daunting, because on first pass you can end up with a very red dashboard, lots of red risks across the top. And what you have to remember is that with a risk, it gets treated, it gets mitigated, or it gets transferred, right? And so you just need to go through those steps, and that reduces the risk. And sometimes that work will be quite intensive, and sometimes it'll be something really, really simple. So I think it's about demonstrating over time the reduction in that risk template to make it seem more palatable to people. And as I say, a lot of there can be one piece of privacy paperwork, a compliant privacy notice on a website can expunge a lot of risks in your privacy program just by producing that one document and having it available at the right points to the right people with the right information in. That could take a long time to write, it could take a short time to write, depending on what kind of organization that you are. And likewise, actually implementing data retention, getting rid of things and moving away from the habit of we keep everything forever because we've always done it, and actually giving cutoff points and deleting data, getting rid of it, shredding paper, means that you are reducing your attack surface from a cyber perspective, but also if you don't have it, you don't have to look after it. And if you don't have it, you don't have to give it back to people if they ask for it. So there are lots of, quick wins within that risk framework that will, I hopefully alleviate some of that anxiety.
Thanks so much, Sarah. Anybody else want to jump in? Andrew?
Yeah, many organizations, I mean, when you look at privacy generally, it's bits and pieces of what everybody does. It's digital transformation, it's risk management, it is project management, it is all of that, right? When we look at risk, most organizations have some kind of an enterprise risk framework. They may not call it that based on their size, but they're looking at what if scenarios. What if we do this, then what? What if we don't do this, then what? So for the risk-based approach, again, keeping in focus what we're trying to protect. We're not just trying to protect data, we're trying to protect people. What's the risk to the people that we are serving, to the people whose data we're collecting, to the people whose data that we're making our billions from? What's the risk to them? And if you understand that, then you start understanding yourself. From the Art of War, Sun Tzu says, if you know yourself and you know your enemies, then you will not lose in 1,000 battles. So once you understand what you have and how that can pose a risk to individuals, and what would the threats out there that can cause that risk to be realized, then you can start taking steps. If you don't take a risk-based approach, what you'll try to do is you'll try to be boiling the ocean. You don't know what you have, so you're trying to do everything. And once you try to boil the ocean, then you're going to be in for a great challenge. So you find out what is going to pose the most significant risk to the organization and to the individual, and then you start tackling those items. As Sarah said, for some organizations, it may be as simple as putting out a privacy notice. Go in chat GPT, you type in the right query, tell a little bit about your organization, it pulls up something, and then you start tailoring it to whatever. That's what some people do, but then you get your professionals to look at it to make sure that it is actually consistent with what your organization needs. They may get your attorneys to look at that. But for some persons, it may mean different things. For others, it may be a situation of doing a whole vulnerability assessment and penetration test, because they have very complex system that is stored in various jurisdictions. So it may be a bit greater, but I'm going to dive too deep into the weeds. So I will break there.
Justine,
Go ahead, Shavaniese.
I'm gonna be short. I don't know if this is a youthful perspective.
Every time somebody say that, it's never short. But go ahead.
Okay. That's a very good legal response.
I'm
I
going
have
to
a
be
quick
short.
question. Go ahead.
Here's the thing. Sometimes you see the verbiage that we know so well is not easily digestible by other people. So sometimes you may very well be saying the same thing, but just use words that they prefer. So yes, you may still be doing what we call the risk-based approach. But if they want to call it compliant or non-compliant, that is fine. And that is what takes me back to what I was saying. Knowing the culture of the organization, knowing the words people prefer to use and how they prefer to operate. But your job, well, our jobs as the privacy professionals, it's really to ensure that they are on the right track, that they're ticking the boxes. So if they don't want to say risk-based approach, okay, let's do our checklist. And you go on the checklist and you can literally tell them, not compliant because you don't have this policy, not compliant because you don't have this. And then now you also go forward, okay, what is my treatment plan? Suppose you don't want to say my risk treatment plan. This is the treatment plan because having looked at the checklist, we don't have this. This is what we need to do to be as close to compliance as possible. So we're gonna have to give and take, as professionals. Sometimes we really have to give and take.
Thank you so much, Shavaniese. And Andrew, if I had $1 for every time a client said I did it on ChatGPT, I would be very wealthy right now. So thank you for adding that to the conversation. All right, so guys, we are going to jump into another exciting part of our discussion, data sharing. And I saw it come up in the chat as well. It has been the topic for the last 2-3 weeks or even months in Jamaica, and it would be remiss of us to not speak about it. We know that confidentiality and data protection are similar, but they are not the same thing. But what we want to talk about is sharing of personal data. When is it permissible? When is it not? Is it permissible at all? Thoughts, guys? Anybody can jump in.
Well, I'm going to be the annoying data protection officer on the call and say it depends, which is the standard answer. It really depends. There are times when sharing data is absolutely fine, and there are times when it's not. It depends on the purpose that you've collected the data for in the first place. It depends whether you have made the individuals aware that you're going to do it. If you've assigned the right lawful basis, if you've protected the transfer between who you're transferring data from 1 and 2, if it feels a bit creepy to do it, it probably is. Don't do it. There's no yes or no answer to this because it really is a case by case scenario. So you have to take it on the level and work out what needs to be done. You may need to undertake a data protection impact assessment to make sure that the rights and freedoms of the individual whose data is being shared is not being compromised by this process. So, unfortunately, there isn't a one-size-fits-all answer for this anywhere in the world, even in Jamaica.
If I may add, right on the tail end of Sara, many people look at sharing as outside of processing, but remember, processing has a very wide meaning and it involves sharing. So when we talk about sharing personal data, in what context are we talking about sharing personal data? Is it department to department? Is it outside of the country? And so that is why, as Sara said, it depends on the circumstances within which you'll be sharing the personal data. That is what will enable you to be informed on whether it's okay or if it's not okay. Did you tell the data subject that you're going to be sharing their data with Andrew and Justine? Yes, but tomorrow you realize, well, in order for me to achieve the actual purpose that I wanted the data for, I need to share it with Justine. What do I now do? Do I go back to the data subject and say, okay, I also need to share it with Justine, or do I just share it and go along because at the end of the day, I told them the purpose for which I needed it? There's so many nuances, but at the end of the day, like Sarah said, if it feels creepy to do it, it's probably wrong. Don't do it. But just ensure that you assess the circumstances as best as possible. Many people also like to leave their legal and their privacy team outside of the sharing of personal data because they think IT is well equipped, because IT is in charge of user authentication and all of those things. So they turn to IT. Okay, I need to share this with so and so. Could you just give me access to do that? Could you give me the credentials to do? And they don't contact legal. They don't speak to their privacy team. So ensure, when in doubt, you ask. I always say that to people.
Yeah. There's an interesting part of sharing that can also lead to transfer. And our standard 8 talks about transfer outside of jurisdiction. You may be sharing data, or you may be sharing personal data that is outside of jurisdiction, and it may require you to do a transfer, some kind of transfer impact assessment, because the data is now leaving your shores and possibly end up in a jurisdiction that does not have adequate laws to protect, and you would have to ensure that you have adequate controls outside of adequate controls to protect that data if the jurisdiction doesn't have adequate laws to support the rights and freedoms of individuals. So that, that's another nuance in terms of sharing data. But I do agree and endorse what Sara and Shavaniese said. It all depends. You have lawful basis for processing data, of which consent is the least of the apostles, I would say. So bear that in mind when you're sharing. Transparency is the other term that you have to be familiar with. You have to be transparent with your data subject. That's the person who the data is about. You have to be very transparent with them about how you're going to share their data.
Thanks so much, Andrew. Justin, do you want to add anything?
Yeah, just to also remind everyone that data sharing is sometimes necessary to transact business. You as a customer, you walk into a bank, sign up for an account. First thing they're going to ask you is your personal information, and you're giving that information up and you're sharing that. And the regulator may need to know who the bank's customers are. And so there are regulatory requirements where then the bank has to turn around and share that information. And that's necessary, to transact, across many businesses. E-commerce, I saw come up in the chat. That's a good example as well. If you are employed to a company and there's a health insurance provider, company has to provide that health insurance provider with all your personal information, including health information and background. And so, when is it permissible and when is it okay? Well, I mean, now companies are required to be transparent about how they're sharing that information. They are required to make sure they get your consent to share that information. Does it stop them from sharing that information? No, but putting the right controls in place to allow those transactions to happen. That's certainly what the law allows us to do, and sort of brings sharper focus to for entities who are sort of preparing to make sure that they're complying with their obligations according to the laws.
Justine, can I just jump in quickly? I think consent's been mentioned several times, and Andrew has his opinion on where it sits in the order of importance of the lawful basis. But when it comes to sharing data, especially outside of organisations, don't forget that legal obligation is going to be a really huge one there. There's a legal obligation to share payroll data with the tax authorities. There's going to be a legal obligation to hand over CCTV footage to authorities. So, even though there's a legal obligation to do something, you still have to assess the risk of doing that and making sure that you've looked at it and it's protected as best as possible. And, making sure that you're aware that the full gambit of the lawful basis is open to you for data transfers and not falling back on consent, because it has to be freely given and it can be withdrawn, and that can cause problems with certain type of processing.
There you have it.
Thank you so much for that. I think we have had such a feast so far, and certainly we know the challenges of getting consent. A lot of people think data protection is the same as you just get consent for everything. So I'm really glad that this panel has made it very, very clear, aside from a lot of other things in terms of what we do need to do to be compliant. And I also want to thank the audience so much for sticking around, because I did hint a number of times that we might have a special guest star. And while this panel is amazing and I'm so privileged to sit here with you guys, I know that there's an elephant in the room. That is registration next month or whenever, right? So the Office of the Information Commissioner, we are so happy to have them here with us, and none other than the Miss Celia Barclay. I'm going to ask if they can bring her on. I see her there, and she has been listening keenly to the discussion. And I will now hand over to you, Miss Barclay, to just speak to the audience about what they can expect.
All right. Thank you so much, Justine, and thanks to everyone for having me and to those persons who have stuck around. All right, so I've heard the discussion, and I must thank the panelists for their contribution to just clarifying the position as it relates to DPA implementation. I note in particular the points that have been made, especially about compliance never being 100%. And that is actually a perspective that the OIC also holds. We regard compliance as a journey. It is something that you work towards and you're constantly working towards. There will always be new steps that you have to take. And as was mentioned, you just have to focus on, first and foremost, where the main risks are, but also more importantly, the fact that your data subjects are humans, and these are the persons that the Act seeks to protect. So if you keep their interest at heart at all times, particularly in making your decisions and taking different actions, then of course you'll be on the right path. So June 1 is around the corner, and everybody is looking to get, or should be looking to get, registered as a data controller. So what are some of the key things that persons need to know as they move forward into June 1? Just to not forget anything, I've noted some points. I'm just going to go through them. You would have heard the announcement in the Senate presentation that we will be taking a phased approach to registration, just as we're taking a phased approach to the implementation of the Act. Now, for clarity, what that means is, come June 1, nobody is prevented from registering. If you are ready to register, then whether or not you fall within the particular focus areas that have been announced, you can go forward with your registration. So if you're ready to register, proceed. However, in terms of where our focus is, we intend to focus on the larger controllers, and particularly those large controllers that have either a high volume of data subjects or process a high volume of sensitive personal data. And so, as you would have heard, and you can look out, we have arranged for a publication in tomorrow's Observer and in both papers on Sunday that will speak in detail about registration. But you would have heard that the focus sectors or industries will be areas like education, finance, healthcare, the ICT sector, tourism, or related sectors. Those areas that we know have a large volume of personal data that they are processing, and of course, where we think the risk may be highest, are where we will be focusing on come June 1, and in particular, ministries, departments, and agencies. So the government is not getting any consideration that the private sector is not getting. The Act has already in some way set them apart in requiring public authorities to have a DPO. And in the same way, we are requiring public authorities to start registration as of June 1. Now, it is a start, as I believe it was Andrew who said earlier. Registration is not a destination, and June 1 is not a deadline. June 1 is when the registration form into which you enter your particulars as prescribed by the Act and in the regulations will become accessible. So we have thousands of data controllers who have already started the process by creating their data controller account. This is the account that will provide the access credentials for you to be able to input your information into the registration form. So persons who have not yet created that account can go ahead onto the OIC's website, go to the My OIC portal and create their data controller account. It requires very basic information, and that will be your first step. You will receive a notification when you are to move forward to enter in your registration particulars. Now, when we talk about large volumes, just to clarify, we're talking persons that have, for example, over 10,000 data subjects that they are dealing with. So the smaller practices, the smaller service providers, the smaller businesses have a little more time to get themselves ready. Now, we also want persons to recognize that in terms of time for registration, the form is set up to allow you a minimum of 30 days within which to complete. And based on the feedback that we have been getting from persons in terms of their readiness and the availability of the information required, especially since the regulations have come out that have outlined what the additional particulars are, we are looking at potentially extending that time even beyond 30 days. But as set now, you have at least 30 days within which to complete the registration form. We have tried to make the form as simple and easy to use as possible, balancing, of course, the need to get in the information that is prescribed. Now, you would see from the Act and the regulations that there's quite a bit that it requires. We have at this stage kept it fairly high level. So, for example, persons have asked, do we have to have a DPIA in order to register? Do we have to have conducted one? No, we are not requiring that that be a part of the registration process or that you prove that you have done one. However, we do acknowledge that having conducted one could assist persons in terms of their preparation for compliance and certainly in terms of being able to identify some of the information that would be required for registration. If you have already done one or any form of data inventory or mapping, if you have those reports or documents already in hand, these are documents that you will be allowed and can upload in support of your registration application. But it does not mean if you do not possess these documents that you cannot register. Now, we're encouraging persons, even if you do not necessarily have all the particulars ready, to still proceed with the registration. What we're doing right now is promoting the registration of controllers. So even if not fully compliant, start registration. Even if you cannot immediately provide all the particulars, start registration. The issue of the data protection officer was discussed earlier. We have had several persons who have indicated that they have not yet identified a DPO or there's a shortage of DPO, so they don't know where to find one. We recognize that challenge, and that is something that it will take us a while as a country to cure that deficit. More and more persons are entering into the market and offering that service. Does it mean that if you do not have a DPO, you should not start registration? No. Identify someone who will be responsible for ensuring your compliance. Over time, we will address things such as whether or not this is the ideal person, right? Remember that the Act also requires persons to update their registration particulars. So it is possible for you to change the details if necessary as we go forward. So again, the encouragement is for you to come forward and start the registration process, whether or not everything is perfect. Now, we allow for the most part for persons to select between options that will be relevant to their organization and their business operations. There are some areas where you are able to enter free text if you do not see the options that are available to you. But as we said, there is also the option of providing whatever supporting documents might indicate what your particulars are and what is relevant to your organization. Now, as it relates to the information that is required, one of the things that I will point out is we know that the Act requires some persons to appoint a DPO, and we also know that in relation to those controllers who are overseas, the Act has asked that you name a data controller representative. In the regulations for those persons that have not seen it and reflected in the registration form will be a requirement for you to identify a direct contact for your DPO or your data controller representative. Sorry, if it is that person or that organization is not a natural person. So if your DPO is, for example, a Securus or a Simtai or the UADP or any company, then you must know that you will be required to name a specific person in that company who can be contacted, whether by the IC in the event that we need to, or by the data subjects who may have queries or complaints. In a similar way, where you appoint a data controller representative, it might be a local firm or partnership or organization, but again, you will be required to name a specific person as the direct contact. If as a controller, you do not require a DPO or a data controller representative, but you are operating, say, a firm or a partnership, you must have some specific individual that can be reached. Now, in that case, it is referred to as the authorized officer. So these are things that persons have to prepare to say who it is that is going to be responsible, even if it is that you don't have a DPO. Now, the other concerns persons have are as it relates to the fees. These have been published and are available in terms of the payment mechanism. As at June 1, persons will be able to pay by way of direct transfer into the OIC's account, and the account details will be published. Now, online on the website will be instructions for completing the registration form. Those instructions will include clarification on different areas of the registration form that might not be so readily clear to, for example, lay persons who are not privacy specialists. And so there will be guide as to how you complete the information, as well as detailed instructions as to how payment is made. We are also building out, as Andrew would have mentioned earlier. And so as we go forward with registration, we will also be introducing additional methods of payment. There will be online payment, which will be facilitated right there on our website. We are also in the process of making arrangement with the TAG for payments to be collected by them in office. So essentially, we are seeking to ensure that persons are able not just to access the form and to register, but to make payment using multiple channels, regardless of where they are located. And even if it is that they don't necessarily have internet access or have access to a credit card. So all of this is what you can look forward to in terms of what June 1 should look like. But the important thing to remember is that June 1 is a commencement date. Before I forget, I will point out that although we are commencing in June 1, remember that the sections of the Act related to registration were brought into effect as at December 1 of 2023. And so when you talk about registration for a year, you are talking about what I refer to as the data protection year. So just like organizations will have a financial year that doesn't necessarily coincide with the calendar year, in a similar way as it comes to data protection, when you speak about a year, you're talking about that period from December 1 of one year to November 30 of the following year. So the 6 months grace period was to allow time for preparation for registration for this particular year. That registration will be for the period up to November 30 of this year. As per the Act, where annual renewal is required, come December 1 of 2023, persons would be expected to renew their registration, and that would include 2024, sorry, and that would include updating the particulars. So as we said, if it is that there are any changes that you would need to make, you have opportunity prior to that time to make those changes, and then on renewal to update with any additional or new information. Over to you, Justine.
Well, I do not know what to say after such an amazing panel, an amazing special guest star. Miss Barclay, you came in at the right time, and I think everybody was really in for a treat today. We've learned so much. I have so many papers and notes, and I'm just so, excited for all the information that we have gotten today. I just want to thank you once again for joining us. I want to thank all the panelists. Your insights were amazing. I also want to just wrap up with just 3 takeaways coming out of our session. The first one is, even if you don't have all the particulars, start registration. Start registration, and it commences on June 1. So get your OIC account ready, get everything together, get your registration particulars to the best that you can together, and start registering. The second takeaway is adopting a risk-based approach and building a culture of trust. That's something I think a number of our panelists said this evening, and certainly it is something that is critical for all organizations as they build out their compliance programs. And the last one is compliance is a journey, not a destination. Thank you so much for sharing that nugget of wisdom with us, Sara. So guys, thank you once again. And I just want to close this evening by mentioning once again that we do have the BizTech 40th anniversary, 40 years of BizTech conference. Amazing. November 13th to 14th. The theme is sustainability and scalability technology for the future. Don't forget to like, comment, subscribe, and follow us on all our socials, which I'm sure will be at the bottom of the screen. Thank you so much again, everybody, and have a great night. And of course, the lines, let me not forget that. Sorry. Thank you so much. We need to put that on the comments. There are the telephone lines for the Office of the Information Commissioner. I think the JTDA can probably put that up. But certainly there are a number of lines. Let me just repeat it for the audience. 876-920-4390, 876-929-8568, 876-960-0874, 876-968-5622, finally 876-929-6952. Email any queries you have to info@oic.gov.jm. Thank you so much once again, and have a great night.
Justine, I just want to say on behalf of the panel, you have been an amazing moderator and host. Thank you so much.
Thank you so much. It was a joy to be with you guys. Thank you. All right. Bye, everybody.